Good morning.
Good morning.
Welcome to the First District Court of Appeals. Today is Tuesday, September 21st, and we only have one case scheduled for argument this morning, which is case number C210133, Andrew White et al. Versus City of Cincinnati, Ohio et al. If attorneys can please identify themselves and their readiness to proceed.
Shuva Paul, Your Honor, on behalf of the City of Cincinnati, ready to proceed.
Good morning.
Good morning.
Good morning, Your Honors. Maurice Thompson, 1851 Center in Columbus for the plaintiffs and appellants, and I'm ready.
Okay, very great. So Attorney Thompson, would you like to reserve time?
Yes, Your Honor. 4 minutes, please.
All right, whenever you're ready, you can go ahead.
Thank you, Your Honor. May it please the court, this case is ultimately about whether the city may force local homeowners to pay an arbitrary assessment to the city for, one, the right to peacefully defend themselves, their families, and their homes, or two, for the right to report entirely truthful information to the city's police, even though it's in the format that the city requires, and it may not do so. Doing so violates the right to self-defense when homeowners do so without calling the city, and speech or petitioning when the homeowners do so when calling the city. The city's alarm assessment isn't a user fee. It's not narrowly tailored to the city's interest in recouping false alarm costs, but ultimately, for these same reasons, it is an unconstitutional condition and a taking or a tax at most. Now, as we discuss these things, bear a few things in mind. There are two key components to this case, both of which this court must decide today. One, the rights of those who use alarms without calling the city, and then separately, the rights and claims of those who call the city after their alarms trigger. And the second category can be further divided into those who call in actual crime in progress and those who call in false alarms. And remember another thing, and that is that all the city's homeowners are asking for here is, in essence, either a return to the 2014 regulations where false alarm costs were recouped by finding those who caused the false alarms instead of assessing those who don't, or a refundable, an end to the non-refundableness of the city's alarm assessments, where if a homeowner does not use the city services whatsoever, there is still no refund under Section 807. Now, the simplest reason that we prevail on all of these claims.
There are in essence two remedies that you're seeking if you were to prevail, one or two, one of the two.
I'm sorry, Your Honor. You were breaking up when you asked your question.
Okay, so if you were to prevail, you're asking for one of two remedies.
The remedy that we're seeking is for this court to enjoin the alarm assessments. Now, after this court enjoins the alarm assessments, it likely will need to remand the case to the trial court for consideration of plaintiff's class claims. And what I'm telling the court is that the practical effect of enjoining the alarm assessment.
You read my mind. You read my mind.
The practical effect of enjoining the alarm assessments isn't some great sweeping revolution in law or even in city policy. What it is if the city were to amend its code to wipe out these prerequisite fees and instead find those who are actually causing false alarms, or on the other hand, end the non-refundableness so that those who never use the city services get their refund. That in addition to quarantining the funds would likely satisfy constitutional scrutiny. So forcing the assessments on homeowners who have only used their alarms to defend themselves and have never called the city is definitely not a user fee, because the alarm users haven't used any city services to defend their home. And finding all alarm users on the speculation that all will contact the city to report false alarms is also not a user fee, because it's not a narrowly tailored method of recovering those false alarm costs. And finally, the city's position that it can charge user fees for police services is not only inconsistent with Ohio law, but it's also unprecedented. And for these reasons, Judge Barrett was correct when he determined, using the same analysis that the Ohio Supreme Court would use and does use in tax versus fee analysis, that the alarm assessment is not a permissible user fee. And when the assessment is
Judge
not a
Barrett
user
made
fee,
that determination in an assessment of a jurisdiction, is that right?
that's correct, Your Honor.
So we're not
Importantly,
bound to that, is that right?
well, there's a strong question as to whether or not the law of the case doctrine would apply and whether it's issue preclusion as well. And that's for this court's consideration. But even holding those,
Mr. Thompson, but wasn't that before any discovery happened?
no, it was not, Your Honor. The city has indicated to the court that it was for discovery. However, that is both false and not relevant. And allow me to explain. We did posit interrogatories in federal court after the city improvidently removed the case. The city did respond to those interrogatories, and that evidence was before Judge Barrett. But equally importantly here, and I think this is an overarching theme for the entire case, is the fact that what really matters as to the constitutionality on its face or as applied is the text of Section 807. And Judge Barrett analyzed the text, which is the correct standard, rather than looking only at the city's evidence instead of the text, which are sometimes at variance. So the correct analysis, one, there was evidence. Two, the correct analysis does not rely upon there having to be evidence beyond the text. But three, Judge Barrett applied the American landfill factors, which is exactly the factors that the Ohio Supreme Court suggested should be applied in cases like Dries. And it's sort of odd that the city goes on to try to analyze whether this is a user fee or not by applying the American landfill factors without any acknowledgement of the fact that the federal court has already done exactly that. And when it did that, it correctly determined that this was not a user fee, leaving the obvious conclusion that it's therefore an unconstitutional condition or a taking. And the primary finding, which is absolutely correct, that Judge Barrett made, is the city's alarm registration fee is based solely on status instead of the use of any city service. And of course, this is true because one need not use the service, but is still required to pay the fee to defend his or her home with an alarm, or even if he or she calls in actual crime in progress. You know, it's as though if you drive a car into the city forces you to pay a parking meter fee when you enter the city, even though you may not use a parking meter. You may use private parking space or may not park at all. And Judge Barrett also held that like-kind calls made to the city do not incur a similar sort of fee. So the fee also does not go into the general fund. Every other case of holding user fees features some sort of quarantining of funds based upon costs imposed. Here we have only an ad hoc indication that fees are voluntarily set aside, but that could change at any time with a new mayor coming in, new priorities. There's nothing stopping a new city administration from taking the alarm users' funds and using them for the streetcar or affordable housing or some other, albeit worthy, government priority, because nothing in the text of Section 807 legally restricts the use of the funds. Nothing in the text of 807 entitles homeowners to any particular service or response, and nothing in the text of 807 obligates the city to provide any sort of response and holds them responsible if it fails to provide that response. And this gets us into the first half of the plaintiff's claims, which is for those who never use city services whatsoever. When a homeowner has used no city services to defend his or her home, it's an unconstitutional condition to charge him or her money for that right. And up until that police call is made, and it might never be made, the homeowner is simply exercising the right to self-defense. Now, that's a rarely litigated right, I'll give you that. but the Ohio Supreme Court has explicitly upheld it. It's called it an enumerated right and a fundamental right. And Ohio courts have extended that right even to things like employing a security guard. And the city says itself many times that using a home security alarm is a recognized method of self-defense and defense of property. The ordinance that the city cites, 448, 1986, says that it encourages citizens to use alarms to help defend themselves, and that alarms provide greater protection against criminals. The city's website indicates that security alarms are a useful deterrent to crime. And the city's website also indicates.
I noticed that you cited that website in a footnote in your brief. Is that something that you have asked? Are you asking us to take judicial notice of that?
Yes, Your Honor.
And explain to me how we are to, under what precedent are we to take judicial notice of a website?
Your Honor, we simply leaked to the homepage of the city's website. It's a government website, it's public. And of course, we had to cite to the website on the date that it was last checked. So I can't verify sitting here today that the information is still the same, although I would not be surprised if it remains the same.
I understand, but under what authority are we to even to take judicial notice of a website?
Well, Your Honor, you don't have to if you don't want to, because the city attached the ordinance that I mentioned to its brief, which does provide the other quotes, which are substantially similar to the quotes on the website.
All right, thank you.
Importantly, the fact that alarms deter crime and do not rely upon the city is undermined by the fact that Section 807, the alarm assessment, requires you to pay the alarm assessment even when you do not alert a government organization. And that's a quote from 807. So in that circumstance, you're getting no government service.
You have about 1 minute left, okay?
Thank you. With that minute, I would like to turn to the free speech issue, which is this, that charging in advance for alarm calls on objections as to their content and as to who is calling violates homeowners' freedom of speech and right to petition, and is not entirely dissimilar from the Lamar Advantage's billboard decision that the Supreme Court recently rendered last week. And that is to say that using an alarm, everybody agrees the way you use an alarm is to posit a phone call to the city's police. And whether you're informing them that the alarm is triggered or demanding or requesting police assistance relies upon their freedom of speech or the right to petition government. It's well established that telephoning police is in fact protected speech or protected petitioning. There are many cases on that, which we cited in our brief. And what the city does is charges on the front end for phone calls like this that you might make, or fines you on the back end if you don't pay that charge on the front end. And this is a sufficient penalty or suppression for First Amendment purposes. It singles out specific subject matter, which is the content of indicating to the government that your alarm has been triggered. And it does so through identifying and suppressing that matter from particular speakers, those who call on behalf of the homeowner. And it's over-inclusive because it charges those who never call in a false alarm, only real or actual crime. And it's under-inclusive because it doesn't penalize like-kind, non-standard or non-general calls that are unrelated to alarms. So strict scrutiny applies, and this suppression of speech or petitioning fails to be narrowly tailored on those bases, and therefore cannot survive this court's review.
Thank you. Good morning, Attorney Shuba. How are you?
Good morning, Your Honors. May it please the court. The trial court did not err when it granted the city's motion for summary judgment, and it did not err when it denied plaintiff's motion for summary judgment. Judgment should be affirmed. The record in this case, and I'm talking about the actual record before the trial court, and I'll get to that, and I'll describe that a little bit more fully in a moment, but the actual record in this case shows that the city is merely exercising its lawful authority under the Ohio Constitution to impose fees to recoup costs incurred in regulating and responding to a certain kind of alarm system within the city of Cincinnati. And before turning to why it's a fee and not a tax, before turning to the other arguments, I think what Judge Bach raised as to what this, what the record really is yes, there was a record that was put before the trial court, but plaintiff wants this court to accept or to believe is that the only record in this case that matters is the one that was put before the federal court. And it's not just in Mr. Thompson's remarks here today, but if you look at page 3 of the appellant's brief, the bottom of the page, appellant's brief, the appellant is saying that the city summarizes the total cost to administer the alarm system program is $192,403 a year. And I can spend my entire 15 minutes going through all the inaccuracies. I don't want to do that, but what I wanted to focus on is that, because that goes to the heart of plaintiff's argument as to why this is an illegal tax and not a fee. That is false.
Mr.
And
Paul,
all you
Mr. Paul, let me ask you a question about Judge Barrett's order and how you would deconstruct it. The only difference I really see than what we have here today, other than the fact you're telling us that discovery was not completed, is that in the order itself, Judge Barrett goes on to say, when evaluating the factors, he says, moreover, the city does not have an estimate for the cost associated with police officers who responded to false alarm calls. Now, I know that there is an estimate now, but does that matter to his analysis, that there is in fact now an estimate as to the cost involved in responding to these false alarms?
Since the federal court, Your Honor, was simply making a jurisdictional determination, no. And the federal court basically laid out a pathway for future discovery, which the city certainly went to follow. Plaintiff decided not to follow that, but the analysis was based on really what was in Exhibit 3 appended to plaintiff's motion for partial summary judgment. For reference purposes, that's docket number 14 in the trial docket. But there, what happened before they filed this lawsuit, Andrew White had an email exchange with Sonia Walker, the director of the False Alarm Reduction Unit, asking a series of questions, got the answers they wanted, which was that it cost $192,000 and change to have her employed, have her database technician employed, and to administer a certain part of the program. 2 months later, the city responded to discovery. It's right there in Exhibit 5, attached to the same motion for partial summary judgment by plaintiff.
But let me ask you, does it matter if those funds go directly into the city's general fund?
Sorry. So yeah. So going back to right. So on the Withrow, that raises the Withrow factors, and yeah, at first glance, without looking at it beyond that, you would say, oh, that tips in the plaintiff's favor. But what that does is simply make us do the full analysis, which means we look at the facts and the circumstances around that. And so the Withrow test, which we explain in our brief, and which the Ohio Supreme Court has been very clear about, is very fact dependent and fact specific. So when we got to doing discovery in the trial court, the city put into evidence the affidavit of Chris Bigham, the city's finance director, who spoke to why the funds in the revenue from the alarm ordinance went into the general fund, but were completely outweighed by the costs of running the city's response. Plaintiff never met their Rule 56 burden in setting forth specific facts to oppose that. They didn't take any depositions. They didn't avail themselves of the tools of discovery. What they wanted to do is lock the city in to what Judge Barrett looked at, which was an email exchange. And actually, if you look at Exhibit 5, the city said, no, those costs are completely an undercount and cannot and are not the full picture. And going back to your question as to whether that really undercuts the city at the end, no. The Dries case shows that the most really important factor is whether there's a benefit above and beyond what taxpayers normally get. And in Dries, Hamilton Township extended their development imposed fees on those residents, put them in a special fund, not a general fund, but yet the court there said, that's a tax. Why? Because what the residents are getting is nothing different from what taxpayers are getting. That's not the case here. What taxpayers get here in response to their taxes is police responses. What the alarm system users in this case are getting is something above and beyond, which is unique, and that's what the fees are meant to recoup. And as Chris Bigham, our finance director, said in his affidavit, which is uncontested, he said it's unwieldy to try to put that in a special fund, because it's not Sonia Walker and her database technician who are going out to respond to these alarms. It's all police officers, and it's the 1,000-member strong department. It's distributed across all 5 districts. It doesn't make sense to try to code a percentage of every officer's time to that. And what makes this tip in the city's favor?
You said that the users of the alarm systems are getting something that's above and beyond. Can you explain what you mean by that?
Yes, and I'm drawing on the affidavit of police officer Rachel Baldwin, Your Honor. That was put into the record before the trial court again, and plaintiffs did not contest it, did not depose her, didn't set forth any specific facts to oppose her on that. But she describes that she's a 20-year veteran of the force who's been out on untold number of false alarm and alarm drops. Alarm drops is the police officer lingo for this. What they get is a 2-officer response instead of a 1, and it's treated as a burglary in progress in the absence of any communication as to what's actually occurring at the premises. That's different from what people, what normally happens when people call 911. You and I call 911 and say, I think
that's for a call drop.
Sorry?
Isn't that specific for a call drop, the 2-officer response?
I think I meant alarm drop. If I said a call drop, I meant
The alarm drop.
Yes.
Yes.
Yeah. So on alarm. So remember, we're talking about alarms that under the code, under the ordinance, the alarm company rep has tried twice to call the owner, and they're unreachable. So to call them a representative of the owner calling the city is a little misleading, because they're not really representing the owner. They can't reach them. And what we have is a call to the city saying, this alarm is activated, and so in exchange for this, under the agreement of and what the alarm users expect is a police response, and what they're getting is a heightened police response in the absence of any communication as to what's happening. That means that,
Mr. Paul, let me ask you this then. What if I'm looking out my window in the evening and I see somebody trying to crawl into my neighbor's house across the street through a window, and my neighbor doesn't have an alarm, and in the end it turns out it's my neighbor trying to get into their house? What is the difference in the response? Would based on that limited information, me calling 911 and saying, hey, somebody's trying to get in my neighbor's house, I give you the address and then hang up. I mean, I assume they would send 2 police officers for that, right?
so
I guess the question is, what's the difference?
yes. So what the difference is, you have the police dispatcher actually talking to a person calling 911 with personal knowledge of what they're observing at the scene. So if it's typically the alarm company rep calling, but in your example, Your Honor, it's you or the neighbor saying, I'm observing somebody crawling into the house. And the dispatcher then will have to determine, is this is a burglary in progress? Is this they have to make a judgment call, and maybe it's a 1-officer response. It could be a 2-officer response. There's no charge for that. That's simply a police response to petition the caller petitioning the police for a response. What's happening here under the alarm ordinance is that
Right, but isn't the underpinnings of the 2 police response because one doesn't know what the police is walking into? So as a matter of safety, there's 2 officers that are dispatched when the homeowner has not been contacted and there's no further information from the homeowner.
Yeah, so in the alarm ordinance case, in the case of an alarm drop, there's no information. The police dispatcher doesn't know what's going on. They don't know if it's a cat opening the door, or a wind, or But yes, they treat it as a burglary in progress. And they
Right, so under your response to Judge Wrinkle's question, there's a discretion that is used to determine, as you said, whether it's a one officer, two officer, or whatever else. It could be a SWAT response, depending on what it is that's being understood or communicated.
Or it could be, as is often the case, it could be treated as a noise complaint. If there's really no other information, it could be a one officer response. That's what happens when there's a noise complaint or illegally parked car, or the two officer response is designated for matters like domestic violence incidents, which go hand in hand with a heightened risk to officers. Heightened risk of violence is usually more than one person at the premises. The officers have to err on the side of caution, even though the vast majority of these alarm drops are result in false alarms. And that's what these alarm system users are getting in response to their fees. They benefit above and beyond what people who call 911 with personal knowledge of what's going on, personal plea for assistance. They're getting something above and beyond. The owners aren't reachable. We have to start with that fact. They're just not reachable. They don't, they're not saying, hey, something's happening here. Can you send police response? If that's what happens, they don't get charged.
Well, let
But
me
the
ask
money-
Mr. Paul. I'm sorry, go ahead, Judge Bach.
Thank you. But the money that is collected, it still goes to police services, correct? It goes into the general fund. It is not specifically for anything other than police services, correct?
Correct. And that's drawn from the affidavit of the city's finance director, Chris Bigham, as city's budget director, as well as the police department's budget finance director, Alice Hochter. The overall police budget is something like 146 million a year. The revenue from this ordinance doesn't cover the costs. Going back to the characterization by plaintiff that the costs are 192,000, that's simply incorrect. The affidavits put in by the city, which we referenced in our brief and which was put before the trial court, talk about the costs vastly exceeding the revenue brought in. And plaintiff didn't, instead of responding to that as that's their obligation under Rule 56, they just seek to try to get the record to be what Judge Barrett saw, and under a theory that doesn't have any weight here. The cost. So as Mr. Bigham said in his affidavit, the costs, the money does go into the general fund, but the costs are only used to defray the police costs, and just logic shows that they can't be used for anything else. There's the costs are vastly exceed the revenue. And that goes back to the withrow factors. So, are they getting, is the intention of the alarm ordinance to recoup costs necessitated by responding and regulating this alarm system? Yes. Do they recoup those costs? No, they don't come, they don't succeed in recouping those costs. And it goes back to what Officer Baldwin said was the city's effort is to not to try to penalize alarm system users, but to try to work with them. She testified to how the number of false alarms is vastly undercounted because when officers respond, they try to work with the owner or whoever's there, the representative who's there, to try to reduce the number of false alarms. They don't necessarily get written up and fined or whatever. So this is the cost of responding to these alarm drops is vast, and plaintiff didn't set forth any specific facts to show how those costs or the revenue is being used to offset other costs. Had they chosen the tools of discovery and before the trial court, maybe we'd be having a different discussion, or maybe I'd have to respond to different arguments, but they're simply sticking to their argument that what Judge Barrett saw is what you should rule on, and that's not correct. As to the, Mr. Thompson talked about, well, we don't know what the city will do in the future. There's no limiting rule on how to use these funds. Well, we have the affidavits of Mr. Bigham and Mr. Hochter unchallenged. They let discovery continue without challenging it. They didn't take any depositions. They didn't ask to. So I don't know how to respond to that, except to say that's speculative. And it's their burden to put into the record specific facts to oppose the city on summary judgment, and they did not do so. So we ask that the judgment be affirmed.
Thank you. Thank you, Attorney Paul.
Thank you.
You have your 4 minutes.
Thank you. I need to unmute there. Thank you, Your Honors. What you see happening here is the city attempting to take this court's eye off the ball. And the ball is the text of Section 807. That is what is challenged here, not some imaginary statute or ordinance concocted through affidavits and summary judgment evidence. And also in that light, we must remember, keep your eye on the ball. The burden is on the city. It is not on the plaintiffs here because of the fundamental rights at issue. And that's made clear in our brief. The text is the full analysis. The plain language of Section 807 is the beginning of this court's analysis, and frankly, also the end of this court's analysis, which is why this summary judgment evidence and these affidavits truly do not matter to the court's analysis. Now, Judge Winkler asked about the fact that there is now an estimate, and the fact that there is an estimate on costs sort of demonstrates the problem of the city's law department coming up with a post hoc, after the fact, scrambling up of costs and revenues, which is, here's what the city has done. It has included the costs of responding to actual alarms where actual crime is in progress, with the cost of responding to false alarms, when in fact, the purpose of the statute is to recover the cost of false alarms. Secondly, it is including the cost of responding, and this is very important, including the cost of responding to people who do not pay the alarm assessments at all. For example, under Section 807, Cincinnati Public Schools is exempt from paying the alarm assessments. That may or may not make sense, but the Cincinnati Public Schools call in 3,000 false alarms a year. They're the number one perpetrator of false alarms. And then third, as a matter of the text of Section 807, irrespective of the good intentions of the city, the fact is that those funds are legally unrestricted. For all we know, right now, those funds may not be being used for responding to false alarms, true alarms, people who do not pay the alarms. It's impossible to hold the city responsible, which is why we require that the ordinance include an aversion to where the funds go. And that's exactly what Withrow required in the Ohio Supreme Court's decision there, a quarantining of the funds by statute, which is what happened in Withrow, to be used for the benefit or protection of those from whom the money was taken. And for all these reasons, there's nothing to be said about the fact that we didn't meet a Civil Rule 56 burden, because the plain language of the text is the issue. Further to Judge Winkler's question, the city's theory that alarm calls are non-standard, non-general, non-traditional, and therefore fines can be assessed for this speech or these police calls falls flat, because there are all kinds of scenarios where people call the police without exact personal knowledge, and it requires a big police response. It could be a nosy neighbor or family member who says, hey, I haven't heard from grandma. Something doesn't seem right over there. Or, hey, I haven't heard from little Timmy, and I believe he might be suicidal or might have a gun. You know, they don't have perfect personal knowledge. They're not in control of the premises that they're calling about. And the police response might not needing to be a big response despite the very little information provided. But there is no charge when people do that. And that is why Section 807 is under-inclusive, because it only charges if the content is, hey, police, an alarm has been triggered, or the content comes from somebody from an alarm company. So it singles out a particular kind of speech. And again, that's when there even is speech. And we have to remember, when we're talking about the city's argument that this is a user fee, that it provides no evidence, despite the burden being on the city, about the percentage of alarm users who actually call in false alarms. It wouldn't be surprising to learn that it's actually extremely low, and all those people are simply defending their property with an alarm and not using city services whatsoever. In that respect, there's no question that the alarm assessment requirement, the prerequisite, is entirely overbroad and violates, it's basically requiring homeowners to pay for exercising the right to self-defense, or requiring homeowners to pay for the right to call the police even when they're reporting actual crime. And for those reasons, the alarm assessment must be enjoined.
Thank you for your arguments this morning. We will take the matter under submission and issue a timely decision. And we wish you both a wonderful afternoon.
Thank you.
Thank you, Your Honor.
That concludes our arguments for this